Okay. Can everybody, I guess there's no one can really respond to me. It looks like people are muted, but if you can't hear me, you can click the raise hand button. I'm happy if anybody wants to interrupt me while I'm talking as well with questions, but I'll get going and then try to look for any hands or any questions that pop up. So my name is Sean Beck. I'm a certified elder law attorney, member of the Special Needs Alliance. This is what I do. Our firm deals with really anything that has to do from a legal aspect of living life with you or with a loved one with special needs. And today I'm going to be talking about the process and the analysis that we do when we do guardianships. And there are a lot of times in these that we don't choose to do guardianships. But there's a few buzzwords I want to introduce you to as we get started. First, guardianship versus conservatorship. A guardianship is it's the legal, it's taking control legally of the healthcare and other decisions that an individual has. So really it focuses just on like health, where you're going to live, maybe where you might work, things like that. A guardianship does not deal with assets and management of someone's assets. Like conservatorship is what Idaho says is over assets. And there's three separate types of guardianships. There's a minor child guardianship. That's if parents pass away or out of the country or something, and they need a guardian to be appointed. There's adult guardianships for incapacitated adults. Like this is where we see an elder that might get dementia or Alzheimer's, and we don't have powers of attorney in place to help manage their decisions and assets. And then there's what's called the DD guardianship for developmental disability. And we'll talk more about, most of you will be really focused on this last one. This is the DD guardianship that is probably more relevant for today's discussion. And they're all a little bit different, but really not everybody who is DD needs a guardianship. And I'll go into that a little bit more. There's another buzzword to remember for that, and that's called supported decision-making. And that's the process of assisting an individual making decisions without a guardianship. Again, not everyone who has developmental disabilities or special needs needs a guardianship. All of us engage in supported decision-making with our spouses and significant others. Like when if I want to buy a car, I usually talk to my wife about it. And sometimes she says no. But that process of navigating a decision and thinking about the pros and cons of a decision is called the supported decision-making. A lot of times we do that with just like a power of attorney document, something cheap, something simple that respects the freedom and autonomy of an individual. Another word you'll hear is capacity or incapacity. When I talk about capacity, it's the ability to grasp a basic concept to make an informed decision. So and it's different for different. The capacity requirements legally are different depending on what you're doing. If you're doing a will, you have to have the capacity to understand your assets and your heirs and your family. If you're entering into a contract, you have to have the capacity to understand the basics of that contract. And when you're looking at guardianship analysis, usually the capacity we're talking about is like your medical for informed consent. And that's the ability to comprehend available medical choices and alternatives and the outcomes and consequences. So those are some buzzwords to keep in mind as we go through today. Remember, alternatives to guardianship include supported decision-making. We always need to think about that. In the last several years, there's been kind of a swing against guardianship and against, years ago, 10 years ago, it was really more of a rubber stamp. If you went in and asked for guardianship, the courts would say, yep, do it. But there was a lot nationally, on a national level, there's been a lot of abuse of the guardianship process, and which has actually led to some positive developments in the area of guardianship where there's been a big refocus on supported decision-making, which is great. Like the Britney Spears story, that one, maybe some of you have heard of. In California, they call it a conservatorship of the person and conservatorship of the estate. And that was pretty big news for a lot of years. There was a Netflix special on it. But guardianship changes, it fundamentally changes some things in some rights of an individual. Whereas SDM, that means supported decision making in this. But whereas supported decision making is less restrictive and allows the person to work with somebody to make decisions. Once a guardianship is in place, healthcare decisions, really the hospitals will look to the guardian to make those, and doctors will look to the guardian. They don't really involve the person as much necessarily. Now, you as the guardian can still try to do that, but they're really looking at you. And the guardian then, that you have no ability, you're not supposed to make reproductive rights decisions. So you're not supposed to do, like, agree to hysterectomy or something without going through a court and getting people to look at that. You can't, the code, Idaho code talks about these restrictions. You can't agree to experimental treatment. So if there's a really severe or a strange or unique ailment that someone has, a lot of times you have to ask the court for permission to engage in what's considered experimental treatment. And same with end of life decisions. We used to have to go to court. The law has changed, but just to do a living will for someone under a DD guardianship, now we can get that done a little easier, like a living will with the person, and without having to go back through court for it. But if you're under a guardianship, gun rights change. You're not supposed to possess a gun. That's a federal law comes into play. Contract rights, you technically can't contract with someone if you have a guardianship. And so if you go and buy a car and you're under a guardianship and your guardian thinks it was a bad idea, they can go and undo that transaction because you didn't have legal rights to even make the contract. And then there's yearly reporting requirements and court review and monitoring that happens when a guardianship is started. When is a guardianship necessary? Why is it necessary? And you heard me talk earlier about capacity. And really, this chart here is on the far left. Think about someone who has full autonomy and they can make decisions on their own. They ask questions, they figure out, they get informed consent when they want to make decisions for healthcare. They're really independently talking with family members and engaging in supported decision making. The next to the right is rudimentary type of capacity. That's where you need a little bit of support, but you can still get there. You can still understand this, what the consequences and weigh your options in front of you. You can express consent, and you still, that's engaging in supported decision making. And really, the line for when it might be necessary, when is a guardianship necessary, is when you get closer to this incapacity line. But there's no fail-safe rule. On different days, different people, we all have different capacity depending on the day. So it's tough to say in each case. And a lot of times we will have a closed case try supported decision making and do powers of attorney. And we'll go from there. And really today, I'm skipping through a lot of that analysis and what it takes to execute a power of attorney with somebody. And I'm focusing on, if you don't think you can do that, what does this guardianship process look like? What does it entail? So we're focusing on, every time you're doing the analysis, think about, do I need any legal framework? Think about just for yourself, how long did you go through life without a power of attorney or any official supported decision making? Probably a while. Most of us do, until we get married or until something happens and we need those documents to do some business or something. So we'll focus on the guardianship conservatorship process and how we get there. But briefly, power of attorneys should be only created when the legal threshold for that and have the capacity to create a power of attorney is when you have the ability to understand the basic nature of the document, what it means, and that you're acting under your own free will. No one's twisting your arm or just saying, sign here, and you sign it and you don't know what you mean. That's technically illegal, and those documents can be thrown out if ever challenged. So you have to have, this is from a case that talks about a lucid interval. When can a power of attorney be made? In that case, is usually dealing with elders who may be getting dementia or something. And if they have the ability to understand the basic nature, they're lucid and they can sign or direct someone to sign for them, then a power of attorney is usually all people might need to have the supported and substitute decision-making legal mechanisms in place. So it is tough though to know when you want to do a guardianship, when you're doing supported decision-making powers of attorney, or to do nothing. And that's when I'm talking, if anyone wants to, by the way, contact me there, I'll talk to you for free about this stuff and help you analyze your specific case and your specific child to determine whether it's needed. But the law says that we usually want a person for whom guardianship is sought to be incapacitated and that they're unable to kind of care for their own basic needs. This is taken from the adult incapacitated guardianships, but there's some crossover with the developmental disability guardianships for kids turning 18 as well. But they're looking for the same thing, which is some evidence of that there'd be harm without a guardian in there to help them make that decision. And now guardianships can be full. That means just plenary, nothing's off limits. The guardian can make all decisions. And then there's also limited guardianships, and those are stressed more and more, especially in the DD realm, where if someone's unable to manage their resources and meet essential requirements for health and safety, this is from the Developmental Disability Code for guardianships. But note that the court's supposed to ask, what alternatives have we even tried? And during the guardianship process, you end up even talking to, at some point, you'll talk to health and welfare, and they'll want to interview you, and they'll want to interview your child, and even lately they want to do that, even interview the child alone if it's possible and appropriate, and if they can communicate. But they want to also double check that a guardianship is necessary. Again, they used to not be as strict about this, and in the last several years they've really bulked up the program. They've bulked up their oversight for guardianships to make sure that no one's falling between the cracks or no one's getting one when they don't need one. Excuse me. So how does this start? Well, the first thing the courts look at is, do we have a developmental disability, and is a guardianship necessary? So developmental disability is we look at something that arose prior, an ailment that arose prior to age 22. It's an impairment. They give you some examples in the code, but I have cases where a kid at age in their 20s gets in an accident, an auto accident, has maybe a traumatic brain injury, and that's not the same type of a guardianship. That would be the incapacitated adult guardianship, and the standards are a little different. And if you go to an attorney who doesn't know those, sometimes they file the wrong one, and then they've wasted some time. But the DD guardianship in Title 66 is the one that most of you guys will be thinking at. And this is the definition here of whether you can even get, if it's even worth filing it, if it's necessary. This kind of helps figure that out. The steps to doing this are not super difficult, but there's some parties who will be involved in this process that you should be aware of. So obviously the court. There's in Ada County, which is where most of you guys will, probably all will be filing. If you do end up filing, there's 2 judges that do this. One's newer, Judge Jill Juries, and she's learning, getting a lot of experience in figuring this stuff out pretty quickly. Judge Beater is the other judge that focuses on this area of law, and he's been doing it for decades now, and does a great job at it. There's when you file, either you have an attorney that you want to represent your kid. So there's 2 attorneys. There's for you as the parent, the guardian that's filing it, you have your own attorney, and then there's your child. And if you can choose your own attorney for the child, and when you file, just have them sign off on it. Or the court, if you don't do it, the court will appoint one for you or for the child. And that's called a guardian ad litem, or GAL attorney. That's right here listed. Let me go back, I messed up. And then the other party that's involved here is health and welfare. They will want to talk about some things. They'll want to meet you. They'll want to see some tests, and they'll want to make sure that it's necessary. If you have other family members that are involved in your child's life, a lot of times they'll be asked questions as well. It just depends on circumstances. If there's 2 parents, 1 parent, if grandparents are involved heavily, then a lot of times they'll be interviewed as well during the process. Pro se, that's self-representation. Yeah, you can do this, something you can do on your own. They used to have some really good forms. They've dialed back a little bit, but there's some self-help forms online at the county's website that you can find. There's also legal aid services. Idaho Legal Aid Services used to help with this and used to help pay for folks that qualified to pay the legal bills and fees to do this. I mean, a lot of times we see these things come out when all said and done, 3,000 to 4,000. Just because there's a lot of different filings, it takes some time, it takes a few months, and then there's a hearing that you've got to go to, and there's that GAL attorney that they appoint. So it can be a few thousand for sure, and these are ways to cut those costs. And if you have the ability to do it yourself, I've got clients that have gone and done it themselves and done it fine. I've had a lot of clients too that get frustrated and come back, but I'm happy to always share these links with anybody who wants to try. There's one more way you could try the Idaho Volunteer Lawyer Program. This is something that I've participated in the past. Again, they look at your income and assets and things, and attorneys who are willing to do it for free out there this program is a great way to do it as well. If you're going with a private attorney, you should really seek a specialist, someone that knows what they're doing, that's going to find the correct type, that's going to ask you about if they're going to tell you honestly, do you really need a guardianship? I'll tell you right now, I probably end up recommending a guardianship in maybe 50 to 75% of the cases that come into my office. The other quarter of the time, 25% of the time, we meet and I end up saying, look, let's just do powers of attorney and let's try this for a few years, see if this works. And a lot of times it does. And then I think I skipped one. Hold on one second. Okay. So first, what you'll do for these, if you're going to end up, if you've got to the point where you've decided, yeah, guardianship is necessary, then you've got some documents that you want to start gathering. And a lot of this is already available and started within the school district themselves. I mean, you've got a psych evaluation that the school districts usually help do, an IQ test, adaptive behavior assessments like the CIVAR, and then a wellness exam. All those things have to be filed and given to the court and then to health and welfare. So if you start the process and you don't have those done, like sometimes a full psych exam, I mean, it could take months to get that done if you don't have an updated one, but those have to be, within the last 12 months is what the court wants to see for that. And then once you've got those documents ready, you get a petition and there's a whole bunch of accompanying documents that you file with the court. And then the court responds. That's where they will appoint that guardian ad litem attorney for the child. Or if you've appointed your own, then they'll be appointed just as an attorney. They'll authorize you to go online and take some training. It only takes like an hour, but the court has to give you a password for that. And then they get a certificate when you're done. And you have to have a background check. Health and welfare helps facilitate that. There's and the law states that they don't want anyone with a felony to be a guardian. And the court will look at those on an individual basis. If you've got some old something in your past that might prohibit you, you can still try to get around that and ask for permission. You've got to create a care plan, kind of explaining to the court what you're going to be doing, what your child's going to be doing for the next several years. Are they going to be doing voc rehab, the STEP program? Are we going to be applying for Social Security? Yes, no. Are we going to go use Medicaid's DD waiver, things like that? And they like to see that you're using what's available. And then there's a health and welfare committee. That's that meeting I mentioned earlier where they'll meet with you, meet with the child, and decide, they'll give you feedback. And I think maybe you don't need a guardianship sometimes. I've had cases where I agree with them, cases where I disagree with them. And sometimes they'll say a limited guardianship. It's really common, more and more common for the health and welfare too, because they send a report to the court and they'll say, well, I think let's do a guardianship, but let's revisit this in a few years and see if it's necessary. Sometimes our kids are just, they're just in the middle of developing and maturing, and they're just not there yet. And the law says you're magically 18 and now you're an adult, but really mentally or physically they may not be, and they just need a few more years. We've had clients that had a guardianship at age 18, and then by age 25, we dismissed it and canceled the guardianship because they'd grown and they'd matured and they're ready to just do supported decision making to help them make life decisions. And then the fifth step after that's done is there's a hearing, and that usually if you've got all your ducks in a row and all your the documents in that are mentioned here, then it's a 10-minute, 15-minute hearing. It's awesome now because it's all on Zoom. So you don't have to waste an hour or two and pay an attorney extra money to go to court for you anymore, because it's quick. So timeline, when do we go file this? Do we do it? We wait till the 18th birthday? And the answer is no. The courts, there's been a lot of cases where you wait too long, and then you show up to the doctor's office when your kid's 18 in a month, and there's an important decision that needs to be made, and the doctors are in a bind, and they have to push it through their ethics committee or something. And really, if you think of this, is something you want to think about before they're 18, 6 months prior at least, is probably a good place to start. But we were walking through this same analysis that I'm talking about today, which is, can they understand the power of attorney? Just, the overarching need, you can sign that. Will they be able to work with me to make decisions? Then maybe a guardianship's not necessary, but then you want to have those documents ready to be signed, the backup documents, the powers of attorney and things signed, so that you can make healthcare decisions for them when they can't. That's in a nutshell, that's the process there. A few other things that I can mention about this is, that we've tried to cut down on the costs of these things. One way you can cut down on the cost is if you've got all those ducks in a row and you've got those all your documents that I mentioned before, and I'll go back to that just so you can take a look at that list. But the school districts have this. They should be in your child's file. And if not, then usually they have a period of time where they have to retest and update these things. And but that's one area that I see cause delay. If people go to file and they don't have those, then you end up having to extend the guardianship and reset the hearings, and that just adds to the cost and the time. And that can be kind of a pain. And then I'm a big fan of picking our own attorneys for the guardian ad litem. If you don't pick yours, there's just a list of people that huck their name in a hat that the judge has, and they kind of rotate through the list, and they just appoint people randomly. And so sometimes you'll get an attorney that doesn't know what they're doing, and they waste a little bit more time, and then it ends up being a little more expensive. I've got a few that it's a pretty small community of attorneys that practice competently in this area. And so I usually will recommend someone that I know that can get things done quickly and inexpensively. And then yearly, if you, let's say you just have a guardianship, again, guardianship is if you're making just medical and healthcare and custody and living decisions for an individual, whereas conservatorship is if they have assets that need managed as well. And a lot of times that does not, one second, I'm losing my train of thought, letting people in the room, but a lot of times, most cases, we don't have to do a conservatorship as well, just because there's not a lot of assets to manage. When someone starts getting Social Security income, for example, you don't have to have a conservatorship to manage that asset. You can do that through the Social Security Rep Payee program. Similarly, if someone inherits some money or something, a lot of times we'll use a trust to help manage those assets and not have to go through the reporting process that a court has for conservatorships. A lot of our clients, if that happens and they're on Social Security and on our Medicaid, we'll help create a trust for them, like a special needs trust, and that allows them to have assets and not get kicked off of Social Security and not get kicked out of Medicaid. Because right now for SSI and for Medicaid DD waiver, if the kid has over $2,000 in assets, they're off the program. They're over the asset limit. So any other questions or anything? It looks like we're getting close on time. Yes, I'm over the time then, 7:30. Brian, can you hear me?
I can, Sean. We're about to start the other session. Could you just
Okay.
provide us with contact information? And they could
Yeah,
contact
let
you
me push
later.
that to the end. So if you look here, there's my email, our phone. We actually moved. We're not at River Park anymore. We're on Glenwood now. I forgot to update that slide, but we moved this last week. I'd be happy to answer anyone's questions if they want to email me. And you should have links to the these slides in the materials. So